I wanted to ask you a little bit about your opinion on the recent Supreme Court hearing on Section 230. I know that you were very
Mhm.
involved in providing input on Section 230 and its relationship to general First Amendment rights in the United States.
I was incredibly heartened that the Supreme Court kept repeating over and over again, like, we're probably not the right people to talk about this. Like I was kind of horrified when I saw that they had taken up that case because just a level of people, the Supreme Court can't actually do much. They can come in and say this party is responsible, they're not responsible. Like that's the level of like what they're able to do. They aren't able to craft remedies independently. So I'll give you a slight example of like a contrast. So like, let's imagine you were an attorney general. So what's interesting, like an attorney general acting in concert with other attorney generals, say of the different states, versus the Supreme Court acting. So they're both part of the justice system. But in the case of the attorney generals, we've seen from things like when they did the tobacco class action lawsuit back in the 90s. So the tobacco companies had been lying for years about their cigarettes not causing cancer. They knew internally that it was. They actively did things like Joe Camel to bring in kids because they knew hooking kids early was really important. And the attorney generals all got together and brought a singular class action lawsuit that changed the rules around how that industry was governed. That is a systematic intervention. It comes in and says like, hey, like it's not just that we're going to have like a before and an after. We're going to like have a transition. We need to have a process where the way we do governance needs to change. The Supreme Court can't do that. They just can't do that.